What's the news with Rekieta?
So multiple aspects. So there are people that had certain factual conclusions about him that have been disproven by the fact that his kids have been returned to him, which doesn't happen if all those factual allegations against him were true. That's fact. That's part one. In this criminal case, a member of our board, a member of Rekieta's board, a member of some other boards, a good, conscientious criminal defense lawyer, brought motions challenging multiple aspects of the search and seizure. Fourth Amendment violations, Fifth and Sixth Amendment violations, and kind of a Second Amendment, Fourth Amendment hybrid violations. So the question is whether statements were coerced from witnesses in violation of their right to counsel and Miranda rights, whether or not the search was procured by fraud, and whether or not the execution of the search was overly broad. Somebody might have mentioned these issues right at the very beginning of the case as staring out from the warrant. And a bunch of the so-called practicing lawyers on LawTube. By the way, if any practicing lawyer on LawTube is giving the kind of advice these people are on the Rekieta case, note to never hire them. The potentially criminal defense lawyer, the legal mindset that has very interesting travel patterns. The Nate the lawyer, go back to being a policeman, I think, or covering like women's soccer or something. Uncivil law, God bless him. Stick to patent law, bro. Now, Good Logic's done great conscientious reviews. Don't always agree with him, but he's done very thorough, fair reviews. But most of LawTube has been utter crap on this. They've made legal look sharp. That's how bad it's been. They made legal look sharp. So a little breakdown of this. So Rekieta's already won on the Fifth and Sixth Amendment issue. So as I suspected, I was like, I bet they did a lot of illegal crap during this case because the whole thing screamed it. It was like, a case like this normally doesn't progress like this, doesn't proceed like this, doesn't read like this. If you've been around enough of these cases, if you've studied enough of these cases, you knew there were sirens going off and red flags everywhere. And it wasn't Hail Marys or special defense of Nick Rekieta or anything else. It was just any case I would look at and say, this case smells like a crap case. So the government has already conceded. Prosecution has already conceded that, yeah, we kind of Mirandized one of the witnesses. And, yeah, they kind of asked for an attorney. And, yeah, we kind of had another cop coerce testimony out of him. So, yeah, we can't put that on because he has confrontation clause rights that are independent. Some people think, oh, unless it's your rights that are violated, you don't have standing. There's a whole bunch of circumstances, either through the confrontation clause or the due process clause, where you can find ways to raise third-party standing effective claims. That I won't go into all the intricacy of it, but there's a bunch of people that didn't understand that basic part. It's like, Lord have mercy. The government conceded it, didn't even fight it, said, yep, no problem, can't introduce those statements. The next set of issues was, as I also kind of predicted, so there's two ways to measure a warrant when you're reviewing it. And this basic thing, a lot of these law tubers can't get, these practicing lawyers can't get. No wonder they have like no history of criminal case success that anybody knows about. Which is, one is you assess the cop, another is you assess the court. So, for example, when you're assessing whether or not there was probable cause for the warrant to issue, that is looking at what the judge did with what the judge said and what the judge knew. And that's based on what the judge was told. And that can be it's misinterpreted as a deferential standard. It's still a constitutional standard, still federal. You get language and lingo like that, but there's also language and lingo that goes the other way. But there's a different way to challenge the warrant. And it's what I said from the get-go, which is you can challenge whether the cop told the truth. It's it's loosely after Franks versus Delaware called a Franks hearing. What it is, you tell the judge, hey, judge, there was information the cop had access to that he failed to tell the judge, and that's how he got the warrant. Mm-hmm. And what's amazing is we don't even require, I think we should, but we don't require, we don't impose a negligence standard. So we don't say the cop with due diligence would have done boom, 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 boom. I think we should require that to meaningfully enforce the Fourth Amendment to the United States Constitution, but we don't. We just say, don't lie. Don't make stuff up. Don't hide stuff. But everything about what this cop did screamed to me from the very beginning, before I'd even read the search warrant affidavit, just looking at the detention warrant, screamed that this cop is a liar. This cop is a fraud. And you don't have to love Nick Rekieta to care about Nick Rekieta to see that. You just have to care about the Constitution of the United States of America and have a little bit of practical lawyering experience. And so turned out the cop lied about tons of stuff. So it turned out that Children's Protective Services had already told the cop what's being alleged does not constitute sufficient grounds to allege any kind of child abuse, least of all a crime. Do you think he included that when he mentioned it to the court? He just kind of forgot to put that in there. The second thing, he knew that the weird dude up in Minneapolis had said all kinds of crazy stuff about Rekieta. He was citing him like he's a concerned citizen. And he just forgot to mention to the judge, actually, he's kind of a nut job, has been saying crazy stuff for 6 months about Rekieta. And then the third part was he claimed, remember the videotape where he could magically tell what was and wasn't white powder as opposed to what is a flash reflection? And he knew from his special video insight that must be cocaine. Extraordinary, even though all the behavior he then describes isn't consistent with taking cocaine. Which I said that screams BS off the plate. Well, of course, he didn't even get the original video. He lied about it. He said, oh yeah, I was watching the original video. No, he didn't even download it. What he did is he saw somebody else talking about it on another video. And this was they discovered this going through the process. So he hid the fact that he watched somebody else's video of something. There's video of me out there with that people have made AI memes of me saying all kinds of crazy things. They have me as Breaking Bad. They have me as, there's over 100 versions of it. Imagine some cop getting a warrant for my house because he watched that. And this guy, he lied about that. So what you request is what's called a Franks hearing. And the prosecution, if they're worried or nervous that they might lose a Franks hearing request, is they go in and they request, we need to have special briefing, judge, give us extra time, If they're confident, 90% of the time, they go into the court and say, nah, here's where they're wrong, boom, 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 let's move on. Instead, they go in front of the judge and we need extra briefing. Also, we need to figure out how we can try to pretend the cop didn't lie or try to get him to tell another lie, or I, the prosecutor, am thinking about how do I get out of this case? If a smart prosecutor uses this as an opportunity to get a plea deal on the table, to get a deal done. That's what a smart prosecutor does. 1 out of 3 cases in drug arrest cases is pled out before the Court of Appeals ever hears of the underlying search warrant issues, right? 1 out of 3 pleads, it gets outright dismissed, right? So, this is the big issue legally in every case like this. But it turned out the cop was completely rogue. Lying, hiding information, fabricating facts, making up claims, intimidating, coercing other cops, intimidating, coercing witnesses in direct violation of their 5th and 6th Amendment rights. And then last but not least, they seized all the guns. Well, there's a little problem. There's no reference to guns in the warrant. The cops had been there at the home previously and had supposedly been following him as a regular follower on his video channel, so they knew he had guns, but they didn't request that the court to seize those. Why? Because they didn't have any evidence it was connected to any criminal activity. Why? Because it might trigger a red flag in a small rural county. Hold on a second. You want to go grab somebody's guns? What's going on here? So, but what do they do when they get there? They're like, yeah, we're just going to grab it. And they grab random stuff, by the way. Well, there's a word for that, or phrase for it. It's called general warrant. And it's called, otherwise known as, for all the constitutionally illiterate practicing lawyers out there, unconstitutional. It's why the 4th Amendment exists, to get rid of general warrants. Now, here's how cops have been trying to get away with this for years. They get a specific warrant saying we're going to get this, and this. And then they go in and they say, oh, it's in plain view. I just saw it. Well, of course, that is basically it, as courts started to figure out, hold on a second, that would be meaning you have a general warrant. I give you a warrant for something particular, but anything you see while you're in there you can take, that's a general warrant, which is exactly what the 4th Amendment is supposed to always prohibit. It has to be particular with what it describes as to what is searched and what is seized. And so that was problematic. They seized all the guns, charged them with things related to the guns. The problem is they had no basis to seize the guns. The guns weren't related to they knew about it before and didn't even request it seizure. Didn't get approval from the warrant, and it wasn't connected somehow. They didn't see, oh, I see the gun connected to this somehow. That makes it a nexus to the underlying criminal activity that you're allowed to search in, because that's the limitation they impose on plain view, which means all of the gun-related charges have to be thrown, and the enhancements would have to be thrown out. So he's got robust constitutional issues. Now, who knows with a state trial court judge? 9 out of 10 are in the pocket of the prosecutor, and they're complete wusses and not willing to enforce the Constitution when it comes to these issues. So that there's always that issue. But if you're the prosecutor, do you really want to keep going forward on this case, which is for the cases you typically have at the bottom of the pile, frankly? So somebody like to party a lot, that's your big crime? I mean, come on. If you're a local prosecutor, you're dealing with real crimes. No, not this, minor stuff. So smart prosecutor dumps this case and doesn't have Fourth Amendment law that embarrasses the entire police department, embarrasses the entire prosecutor, potentially embarrasses the judge. That's what the smart prosecutor would do. But I don't know if they got a smart prosecutor up there.
Did they? But now I remember in the original charging documents, or at least when we got additional documents, it said that the way they got to the felony amount of the cocaine, or whatever it was, 25 grams, was by including the packaging. Have they reduced that, or is there?
They added that. They haven't. At some point, they're going to have to reduce that dramatically as well. So a lot of the charges are already coming off because his kids are already back, which meant those claims are all crap. The guns should be thrown out, so that means that's all crap, and the enhancement's all crap. The measurement was always crap, so they have other issues. I'm sure there's probably other evidentiary defenses. But the problem is the cop lied repeatedly to get the warrant. If you take out, so what's materiality? Materiality is, why did they put it in the warrant? This is how I always respond when I've dealt with these issues in front of judges. Said, Judge, if it didn't matter to the warrant, then why was it in the warrant? Right? And so 9 times out of 10, if it's in the warrant, it's material to the warrant.
Like the evidence in the New York case.
Yeah, exactly. Now, if you take out, and I mean, there's other stuff they haven't even got into yet that's problematic in the warrant. But this is just, did the cop lie? And it's just requesting an evidentiary hearing. Say, let's have an evidence. Let's put the cop on the stand. Let's get the evidence and let's see what happened. Did he lie or not, Judge? You get to assess him. You're here every day. He grants him that hearing. If you're a prosecutor, you look at this file, there's no way you let that dimwit get up on the stand. You let a cop that's so dumb, he lied about stuff they could prove with things that were sent in the mail? Never in writing, always in cash. This cop clearly forgot that lesson. It's amazing. Corrupt cops love to print. They write this stuff, but they put it in emails and other communication. They're just because they convince themselves of their fraud and their lies. You've got a completely crooked cop here. And you got multiple crooked cops because there were other crooked cops at the scene doing illegal things. So you got multiple levels of crooked cops. And someone's going to convince me it's a total coincidence that the person being targeted is one of the biggest critics of the local law enforcement community? Come on. I mean, what world do you people live in? You don't have to believe in tentacular conspiracies. They saw an opportunity to screw somebody that had been a pain in their rear, and they decided to do so. It's simple as math. That's why I live in Vegas, but don't practice law in Vegas. I don't want these boys knocking on my door. So I'm careful where I come out. I parachute in like a mercenary and I get back to my Swiss mountains. It's clear that this has crooked cops written all over it. And if you're a smart prosecutor, do you let that crooked cop be an idiot take the stand? God knows what dumb lie he's going to make up. This guy was dumb enough to lie about things there's written proof of. So if you're a smart prosecutor, you get out of this case now. You finish this, conclude this, write this up. But I don't know if they're smart enough, so we might get to see these crooked cop embarrass himself right on the stand.